McKinnon Legal Podcast, your guide to brighter paths beyond challenging marriages. Here's your host, Christina McKinnon.
Hello, everyone, and welcome back to episode number 2 of the McKinnon Legal Podcast. I'm your co-host, Jeremy Wolf, and I am here with your host, Christina McKinnon. Christina, good to see you again.
Hey, Jeremy, how's it going? Always good to see you.
Yeah, likewise. It is going really well, getting ready for the holidays, actually coming off a week of illness last week, so I'm ready to get a productive week started here, and I figure no better way to start the week than with Christina McKinnon.
Well, glad you're feeling better. And yes, absolutely. I want to start the week this week talking about a very important party to the case, a Guardian Ad Litem. As we gear up for the holidays and breaks, winter break is upon us next week. You know, I've had lots of cases, evidentiary hearings, and even some trials this week, in fact, that involve a special evaluator and investigator called a Guardian Ad Litem that's appointed for the best interest of the children. This person is a facilitator, like I said, an investigator, but they are most importantly appointed to evaluate the best interest factors in the statute to determine when there's a contentious custody battle. Well, in the state of Florida, we don't use the term custody anymore. It's no longer a legal term. It's called establishment of a parenting plan. It's called, coming up with a time-sharing arrangement. But when parties can't agree, this is what the court, or this is who the court will listen to, not abdicate their authority, but, go forward on their recommendation because they have the specialized training and the ability to remain neutral. The parents do not. To be unbiased. The parents do not. When someone is either divorcing or is no longer in a relationship with a child, there is a tendency for them to try and alienate the child from the other parent. So, this is something I think is very important, Jeremy, and I think that the parties should, be apprised of what the factors are, when to request this Guardian Ad Litem, and how it can help your case.
Now, is the Guardian Ad Litem, is that something that's court appointed, or do you, as the private attorney, go out and find and choose your own Guardian Ad Litem?
Well, I mean, a Guardian Ad Litem can be agreed to by the parties through their attorneys, or if they're not represented by attorneys, parties can certainly do the matter pro se or unrepresented. And if the court believes that the parties cannot co-parent and the parties are so contentious, there's so much acrimony in the case that it'll just be a tit for tat, one party against the other, and neither one is putting the child's needs above their own, then the court can in fact appoint that Guardian Ad Litem. What happens is a lot of times the court will defer to the attorneys on the case and say, hey, you all come up with someone that you all agree to. Me being practicing for at least 2 decades here in South Florida, we have a short list of people that are our go-to guardians, but the other side may as well. So just by a process of elimination, we can come up with who we think is the best for the issues in the case.
Does it have to be one, or is there ever a case where there's one for each side? Does that make sense?
No, there's one in the case. So okay. Even if there are multiple children, so there's one Guardian Ad Litem that is going to investigate the circumstances of this case, the parents in this case, be appointed as the next friend for this particular child or these children, speak with the school administrators, speak with the teachers, examine the records if that's a part of the order appointing them, speak with any mental health evaluators or psychiatrists or therapists that are there, even speak with the neighbors. So that one Guardian Ad Litem may be on the case, I would say on the low end from 60 days to maybe about 4 months to get a thorough investigation to make a proper recommendation to the court.
So in situations where a divorce attorney has a differing opinion with the guardian ad litem on what's in the best interest of the child.
Mhm.
How is that typically resolved from your experience?
Once again, from my experience, I've had, situations where guardians ad litem were, for my client, and I don't want to say for my client because they're supposed to be neutral and unbiased, but they've issued a recommendation that was in my client's favor, and I've had them that were not so much in my client's favor, and it depends on what the um, evaluator or what the investigator recommended. First, I go through the best interest factors that are in 6113 sub 3 of the Florida statutes and make sure that each of those 20 factors were thoroughly investigated. If some were omitted, or I believe that it was weighted a little heavily on one side than the other, then that's my responsibility to attack the credibility of that guardian. I do have a certain list of factors that I sort of go ahead and I personally evaluate, whether or not they are acting as a lawyer. Now, they can be a lawyer, but they don't have to. Guardians ad litem have specialized training that they must go through about 15 to 20 hours of training before they can, number one, be able to work with kids, give, age appropriate discourse or conversation with a child, and then make appropriate recommendations to the court. They have to be apprised of and informed of the statutes that are applicable to being a guardian ad litem, 61, 401, 402, 403, I think all the way through 405. Chapter 61 is the sort of family statute, which is divorce, parenting, child support, alimony, and other factors. So they have to know what the statute says if they're non-attorneys. But someone who undermines the attorney's legal advice to their own client, someone who can't maintain confidentiality. The big kicker that I see is, they fail to file a notice of intent to interview any witness or has commenced interviewing the parties or collateral sources without informing one or both of the attorneys. Spending way too much time speaking with one attorney and not the other, or one party and not the other, and failing to stay in reasonable communication with both parties and, updating them on the status of the case. So, those are some of the factors you can, sort of see when people have overstepped their bounds and gone out of the authority of what or the requirements of what a guardian ad litem should do. For me, those boundaries are, not playing one party against the other. Someone who may be passive aggressive or communicates in a way that is hostile or disrespectful to one side or the other, buying expensive gifts for the child, so certainly you want the child to warm up to you as a guardian ad litem, but those type of favoritism behaviors are inappropriate, I believe, and they do overstep their bounds. Those are key factors that pique my interest. And if there is a recommendation or an evaluation that goes against my client or what I feel is the best interest of the child, I'm very well able and willing to attack the credibility at trial. All right.
Sorry,
visitor.
we got a little happy visitor. He's getting excited here.
That's fine. That's fine.
So what advice do you give your clients regarding working with a guardian ad litem, and what can they do to facilitate a smooth process?
Well, you know what? First and foremost, I tell my clients to be very open and honest, very forthcoming. Tell them every concern that you have. Don't disparage the other side. But if it's a legitimate concern, I'm going to know about it as the attorney, and we'll go through, hey, what's okay to express or how to express those to the guardian ad litem. The second thing is provide as many witnesses as possible. So you want to give the appearance of neutrality, right? So, when people are involved in a relationship that tugs on the heartstrings, there may be some, I don't want to say ill will, but there may be some unresolved anger, unresolved frustration toward the other parent. So this is why the judge wants a guardian ad litem appointed, or this is why the attorneys both came to the agreement that a guardian ad litem is necessary in this case. So for them to get neutral third parties or neutral witnesses, whether it's a neighbor, other family members, the friends or teachers of the child, that's most important. And the more witnesses that you can provide, the better view, the better scope that the guardian ad litem has from which they can make their recommendation.
Yeah, that makes perfect sense. And any contentious issue, the more neutral third parties you could have bringing their feedback, the better for all parties involved, for sure. Is there anything else that we didn't touch upon that you'd like to share before we wrap up here?
The most important part is that the guardian ad litem is a party to the case as well. So they're appointed for the best interest of the child, next friend of the child, basically as if the child were speaking to the court. So in theory, well, I wouldn't say in theory, in essence, the general rule is that children don't testify in court. Certainly there are exceptions to that. I can do a motion for child testimony, or what we call in-camera testimony, where the judge takes the child to their chambers and asks age-appropriate questions so that they can glean the information they need to make a decision. But the fear is that, there's going to be a child on the stand testify against one of the parents, and that's very damaging, right? And that too itself would make one parent either retaliate or appear as if, they are the lesser parent. So the court wants to protect the child and, of course, protect the relationship. So this guardian ad litem is appointed to the case to protect a child from testifying in court. So that means that hearsay is waived. Anything the child says or any of these witnesses say can come in through the guardian ad litem. So that is, different when I'm dealing with any other witness. They have to testify as to what their personal knowledge is, what they know or what they've observed. This guardian ad litem can testify as to what someone told them, right? Because hearsay is generally waived. The other thing is that as they are a party to the case, they can be called by one or both of the attorneys. So if I'm calling them as my witness, I will be, prepared to put on their report as evidence and introduce it as something that's in favor of what we are proposing to the court, how we want the court to rule. If I am cross-examining that guardian ad litem, then more likely than not, I'm attacking their credibility and seeking to discharge them for doing something inappropriate with some of those factors that I've gone through before.
Very cool. So coming into this episode, I had heard, probably like many other folks out there, had heard the term guardian ad litem, but just really didn't know exactly what it was. So this was very insightful. Thank you for your thoughts and sharing. It was rather informative. So always a pleasure to see you, Christina.
Always a pleasure to be here. And you know what? In the new year, I'd like to have some of those very competent and very effective guardians on the podcast. So stay tuned.
All right. Sounds good. And to our listeners, thanks for tuning in. And we will catch you next time. Everyone have a wonderful day and happy holidays.
Happy holidays.
Thank you for joining us on the McKinnon Legal Podcast. Remember, there's always a path to a brighter, happier future. Stay tuned for more positive insights on troubled relationships and legal solutions. For more information, please visit mckinnon-legal.com. That's MCKINNON-legal.com or call 877-920-1614.